Viewers, you are well aware that I am Dr. Jetling Yellosa, running a YouTube channel called Law Speeches. In my channel, I am regularly posting my lectures on various facets of law as well as the topical world issues. Today, I am delivering my lecture on child marriages in India. So this is a some extent burning but not so burning as that of the before to the independence period. You know, one of the social evil in Indian society is facing is child marriages. Mostly in state of Rajasthan, Haryana, in southern states like Tamil Nadu, the eastern states like Jharkhand, Assam, we could find this incidence of child marriages. In, if we take the data of the child marriages, the, which reveals that in 2023, Tamil Nadu topped the child marriages in India. And in 1981, there were 44 child marriages were reported. In 91, it is a 36. 2001, 15. 2011, 4. So day by day, because of the efforts made by the government, its officials, and awareness created by the government and social spirited organizations have been seeing the occurrence of the child marriages are decreasing. But still it is there. And there are some marriages is happening without reporting. Secretly they are performing the child marriages here and there. You know, child marriages have its own problem. Like if a child is get married, her growth was retarded. And the early marriages lead to maternity deaths and infant deaths. In addition to that, we have the fertility problems and which leads to lot of disturbances in the societies and the families. So basically child marriages are a kind of a threat to society. You know, since British Raj, the child marriages were there. Before to that also in ancient India also, if we see the historical perspectives, we could see the occurrence of child marriages everywhere. But the first time when the Britishers were ruling us in 1929 to curb the child marriages, then the government has enacted the Child Marriage Restraint Act of 1929. So this act was basically curtailed the eradication of the child marriages, but not completely has been eradicated. And to overcome it, we enacted another act called the Prevention of Child Marriage Act of 2006, and popularly called as the Act number 6 of 2007. So this the main purpose of this act is to eradicate the child marriages from the society and to free the society from any sort of child marriages. And this act, though considered as a comprehensive enactment, we discuss some of the important provisions of this Act of Prevention of Child Marriages Act of 2006. As well, you are aware that basically all the enactments, the section 2 provides definitions. Here also it is not exempted. Section 2 gives some important definitions like the child. Under section A, where a child is a person, if he is not a male, she is a female, she be considered as a below the age of 18 years. In case of male, below the age of 21 years. Then child marriage is defined under section 2, clause number B, where it was stated either of the contracting party is a child, that could be called as a child marriage. So either of the party, not the two parties, but either of the party, they are below the marital age, then that could be called as a child marriage. Then section 2 class C provides district courts have been empowered to entertain all the petitions with regard to child marriages, and the district courts can further delegate the power to the family courts, or in some extraordinary conditions they can give the power to the judicial first class magistrates. Then another important section is section 3 of the Child Marriage Act, which provides that either of the party is a child and either of the party has the option to avoid the marriage. After the marriage, they can come out from the marriage. That section 3 is there, that we call as they can say that it is nullity privilege is provided to either of the parties, and that petition has to be filed in the district court where the child marriage or children are residing. After marriage they are residing. And the another important aspect is that within 2 years of attaining majority, here a majority means we have to go to Indian Majority Act. So majority is attained after 18 years of age. So after attaining the 2 years of majority, within 2 years they have to file nullity petition. And there is one important aspect is that if the female, the age is 18 years to be considered a child marriage. For the male it is 21 years. So 18 plus 2 becomes 20 years. Within 20 years they have to file the nullity petition in case of the females are concerned. But the males are there, it is 21 years, 21 plus 3, 21 plus 2, so it is coming to 23. So there is an advantage to the males rather than to females. So regarding this, some cases have been filed, and in one important case like the Sanjay Chowdhury versus Guddhan 2024, very recent case, the Allahabad High Court has categorically stated that a person got married at 12 years of age, and woman was at she was 9 years. So they filed a petition under the PCMA Act. So after that, what happened? There is a more advantage is there. This court has held that this PCMA Act is differentiating between the male and female. It is nothing but a sort of a discrimination. The nullity of marriage can be, for in case of the female, 20 years, she can file a petition, but in case of the male, it may be 23 years. It is nothing but it is a violation of that principle that was held by the Allahabad High Court. Then Section 4 of the Child Marriage Act also provides that if there is a nullity of marriage was declared by the competent court and all the items which were exchanged are given at the time of, during the time of, after the time of the marriage, they have to be returned back to respective parties. And that is a mandatory provision everyone has to observe. Then the Section 4 of this PCMA Act also provides that the maintenance provisions. So the male has a liability to maintain, whether it may be temporary maintenance or permanent maintenance or permanent alimony, that should be given to the female. If the male is unable, the male also a child, in such a scenario, the parents have been given a duty to give the maintenance to the female. That is there in this PCMA Act of 2006. Then we have Section 5, which speaks about the custody and maintenance of the children. So, for these matters, if the children they have begot the child and the custody issues are concerned, that only to be decided by the competent district judge. No other court has the power to interfere in the custodial petitions of the child marriages births. Then Section 6 speaks about the legitimacy of child born of child marriages. So, if the child is born, what is the legitimacy? For that purpose, the section provides they enjoy all the rights over the respective parents. That is there under Section 6. And Section 8 speaks about the so district courts have to oversee all sorts of the disputes with regard to child marriages that has been provided in this Section 8. Then Section 9. If a major person marries, a male major person marries a female child, in such scenario, the male person, the non-minority person, the person though having the age of about 21 years, is liable for punishment and is liable for 2 years of imprisonment and also a fine. Then Section 10 speaks about the persons who solemnizes the child marriages. So the persons who involved in solemnizing or performing the child marriages, they conducts or directs the child marriages, they negotiate the child marriages, they are rigorously punished for term of the 2 years, and also the 1 lakh fine can also be imposed against them, or both can be imposed off. That is to prevent the child marriages. This kind of Section 10 is inserted in this Prohibition of Child Marriage Act. Then Section 11 also speaks that whoever promotes or permits the child marriage, that means the marriage negotiators, parents, or the persons who attends or who abets the child marriages, they are liable under this section and they also been punishable for a term of 2 years and 1 lakh fine or both. That is a rigorous section is inserted into Prevention of Child Marriage Act to prevent the furtherance of the child marriages in Indian society. Then the section 13, another interesting section, which speaks about that if anybody knows that some child marriage is going to be conducted in such a scenario, the the persons can approach the court and then get the injunction for not performance of the child marriage. And it's a duty of the child protection officer of the district to lodge a complaint before the judicial first class magistrates, and they are empowered to give the orders of injunction for prevention of the child marriages. Then section 14, which speaks about the child marriages injunctions which have been given are permanent in nature, that cannot be revoked till the age of attainment of the marriage age is met. Then till then it cannot be, injunctions cannot be overridden or to say set aside. Then section 16 speaks about the child marriages prohibition officers. There in every district, this administration has to maintain the child marriage prohibition officers, and they have to, their duty is to prevent the child marriages which may happen within their jurisdiction. If anything, the marriages are happening, they have to lodge a complaint, go to the police station, prevent the child marriage. That is a primary duty is castigated upon them. So, if you go to some sort of history, when the British was ruling us, the child marriages were at that time, age of marriage was 14 years to the girls and 18 years to the boys. But after we got independence or we got republic, then the marriage age for the females is prescribed as 18 years for females. In case of the males, it is 21 years. When the Britishers were made the 1929 Child Marriage Restraint Act, some Muslims organizations strongly protested this sort of prohibition. But the good sense prevailed, and the act was being amended, came into force in 1929. Then another interesting case that is very important also, that is the Supreme Court case of India, the Independent Thought versus Union of India, 2017. In this case, the Supreme Court has opined that, I quote here, men could file annulment petitions till the age of 23 years. But this kind of providing 23 years to the males and for females only 20 years, it is leading to discrimination, which is against the principles of Article 14, 15 of the Constitution of India. So the many social organizations and public spirited persons, they are demanding that there should be equality of the age of the marriage. So with females also it should take into the 21 years. This rule of 18 years to females and 21 years to male is outdated now in the present society. That was the argument made by being made by the main number of organizations and even number of reports like the Enfold Poaching Health Trust and Civic Data Lab has came out that this sort of arrangement should be rearranged. They made a lot of research upon this and they have demanding that there should be universal marriage age should be there. Then only we could avoid the discrimination. So for any society, the child marriages are not recommended. And the society, the people involved should rethink about the child marriages because the child marriages lead to lot of health problems which is not good for the society and which have the evil effects upon the society. We have to curb the evil from the society. So with this I am concluding my lecture. Thank you for patiently hearing my lecture, and once again I request all of you to subscribe to my channel which is called as a Law Speeches on the YouTube platform. Thank you one and all.